Hello, my name is Mel, and I'm the Rights Officer for the Unlocking Our Sound Heritage project at the National Library of Scotland, and today we're going to talk about copyright in sound archives. This presentation will look at an overview of my process for clearing sound recordings in terms of copyright. I'm also responsible for the data protection side of things, but this will just cover copyright. So copyright protects fixed, original expressions of creativity. In order to qualify for protection, an idea must be fixed, and recording sound is one example of fixing an idea, so anything that is recorded qualifies for copyright. Any kind of copying of a work that is in copyright counts as infringement unless there is an exception or provision in the law to permit such an act. Copyright is finite, however most of what I work on is still in copyright. Once digitization and cataloguing are complete, I then begin my job, which is to clear recordings to make them available online by getting a license from the copyright holder. Copyright in sound is particularly complicated as it can have many layers, and we call these embedded rights. There will potentially be a different rights holder for each layer of rights. For example, an oral history recording with two people, one person interviewing the other. The person making that recording, the sound recordist, owns the copyright in the recording itself. The two people speaking also each own both the copyright in their performance and the literary copyright in what they're saying. However, if one of those people is making or being part of that recording in the course of their employment, then that copyright will automatically belong to their employer unless their contract states otherwise. It is also possible for copyright to be assigned or sold or inherited. It works just like a piece of property. So perhaps the interviewer in that example has given the interviewee a form to complete, which assigns the copyright to the employer the interviewer is working for as well. This would make my life much easier, but it's often not the case. The first thing I do then is to look at who owns what and to check with the relevant people if the people you believe own the copyright do in fact own that copyright. For example, I would interact with the employer of the interviewer, perhaps an oral history charity or maybe a university, to find out what kind of arrangement they had with the interviewer and what documentation there is for interviewees. Once it's determined who the copyright likely belongs to, I think about getting in touch with that rights holder. To find the rights holder, I follow a diligent search process, which is similar to the process required to register an orphan work under the Orphan Works exception. However, if the UK leaves the EU, we will not be able to use this exception, which would enable us to make use of works in copyright where we cannot find a copyright holder. But we still follow the same process as it's a really good standard for searching for rights holders. However, as mentioned, we cannot rely on that exception for protection if at the end of that search we do not have a license. What we can do is to use it to inform a risk-based judgment about making a recording available online anyway, but that's going to be down to each institution's appetite for risk. I look for a way to contact a rights holder or potentially a family member or descendant if they've died, using a variety of sources. These vary depending on what kind of collection I'm working on, but they include Find My Past, which is a site similar to Ancestry, which has electoral roll and birth, death, marriage records, etc. Google, social media, the British Newspaper Archive, Scottish Land and Property Registers, the Watch File, which is writers, artists and their copyright holders, obituaries, and I may also engage, or I will also engage with the collection holders and curators and the original creators of the collection, as well as any rights holders I can get in contact with who may be able to give me information about other people involved in the project, for example. The success of each of these resources often depends on what kind of collection it is and how notable the people I'm looking for are or were, and this can obviously skew what you make available in favour of people who are likely to be on Who's Who, for example. And I think that shows why it is important to consider reasonable risk. So, for example, if I complete a diligent search and can't get in contact with a rights holder, then that combined with a good takedown policy should likely be enough. Otherwise, the collections we are able to make available will be really skewed in terms of how easy it is to find and contact the rights holders. Once I am able to get in contact with a rights holder, I'm looking to get them to sign a document that grants us a license. We don't ask rights holders to assign copyright, just grant a license. And we use Creative Commons licenses, which are all non-commercial and offer a variety of options depending on what the rights holder feels comfortable with. At this point, it is important to try and build a relationship with that rights holder. I want to make sure that they feel trust in our institution and in what we're doing with the recording. But I obviously never make a rights holder feel pressured to choose one option. I just give them all the information to make a choice and make sure they understand what it would allow us to do if they choose the more open license, which obviously we would prefer. Rights holders often have lots of questions for me, and I do send them all the information in writing, but often I find they feel more comfortable discussing things via email or over the phone with me going through things directly with them. It's also often helpful to explain that we review all recordings for data protection purposes before making them available, which can improve confidence in granting a license, and it gives them an opportunity to flag anything in the recording which we may not already be aware of, which might be a concern, although we do not ask for consent in a data protection context. Some rights holders can be really chatty about how the work was created and give more contextual information, which is often really interesting and even potentially useful. I also find that the first impression is very important. So I try to send documentation via email or letter before I attempt a call if I have a phone number, as people can be quite on guard when they receive what is essentially a cold call. And I do also have to be aware that some of the people I'm contacting might be very elderly or in poor health, or that I could be speaking to someone about a deceased member of their family or a friend. So I have to be really sensitive and respectful when having those conversations. In an ideal world, you'll have been able to find your rights holder and get a license, but it doesn't always work that way. And in these cases, if we don't have time or resource to do that diligent search style approach, then we might want to think about using the exceptions that are available to libraries and archives. And these include providing a single copy of an unpublished work, providing a single copy of a published work, fair dealing for research and private study, illustration for instruction, and criticism or review. But obviously you'll need to look at the full details of when these are applicable to make use of them. So that's a very quick overview of how I work with copyright and sound recordings at the National Library of Scotland for the Unlocking Our Sound Heritage project.